Welcome to Environmental Law course, dear learner and viewer. Today we are going to discuss about the water law and policy in India. After having considered elaborately about the Environment Protection Act of 1986, we are sliding to a different discussion, which is one of the major constituent of the environmental law and policy in this country, and that is in water law and policy in India. Under this lecture, what we plan to do is to understand the water crisis by taking into an statistical study and having a cursory glance that how water happens to be a major crisis. But before we understand what major crises are, that Indian economy and India as a country of the rich environmental resources and the water resources happens to be on the throes of transition, the two things must be studied. At first, that water is considered to be a metaphor of the power, and legally speaking, what we have the scientific inputs about the water and the water quality and what happens to the water resource management in this country. Legally speaking, we must understand, because we are going to discuss primarily the water law and we are trying to pull out the policy framework in India in our discussion and lecture on the water law and policy in India. So we begin that water is a metaphor of the power. At the same time, we also know that the water is elixir of the life. And if we understand both the concept and notion that water is an elixir of life, and having the elixir of life mean that the scarcity and the crisis of the water is something very formidable and threaten the entire existence of the human being on this earth. Therefore, in this direction, that being an elixir of the life, the India faces an acute crisis and the critical water crisis, with only 0.124% of the earth's total water which are available in rivers, stream, lakes, wells and tube wells, and therefore the water scarcity demands our urgent attention, and that remains the focus of the water laws and policy in India, the present lecture. And we try to see the present lecture from that the country which is endowed and bestowed with the water resources happens to enjoy more power and happens to have more a kind of a delegation of the power, and the countries which are water scarce happens to be at the loggerheads, not being that their human survival happens to be in danger, but at the same time the country's economy is badly affected because of the water crisis. Under these circumstances, we try to see the water crisis to be a kind of a legal solution, what legal solution we can have about the water crisis. And then we see that Indian context, what is important, that the India is a riverine country and all major rivers in India have become now in the present circumstances as sewer. So the very alteration of the characters of the rivers to sewer is something as a very alarming situation in reference to what is called the water policy in India, and that creates a major and formidable challenge for the water law to grow in this country. As we see that out of 3,000 odd towns and cities, barely 7% treat their sewers, and rest dump the waste directly into the rivers or seas or the water aquifers or the land. Then out of 132 industrial plants which have been studied are pumping their water into the major rivers like Ganges and Yamuna, and only 12 have waste treatment facilities. Then we see that the legal angle or the law which is going to be clamped on the water resource management in this country or the industries in the country, because the basic law appears to be that no water is to be discharged without a proper treatment, and that fundamental aspect of the water law have not been taken to its logical end. Thereby we see that most of the rivers in this country are not only badly polluted, and their waters are not fit for drinking and as well as for the bathing and for agriculture purposes, because of the pesticide residue and the chemical generation in the water. and this remains a very alarming situation, and India happens to be on the throes of transition in matters of water resources and the water crisis, despite the fact that India has been bestowed and endowed with a great degree of the water security, water resources, rivers, lakes, and ponds, gushes in this country. It is a very critical situation to meet at one hand the demand of the human survival as an elixir of the life, on the other hand to see the water from the parlance of the power and the metaphor of the powers. And with this lecture, we try to see and we try to focus that the very canvas of the water law and policy in India, and in that reference, we will see that how this water crisis, going by the number, appears to be a very daunting task for our planners and the legal policy holders and the practitioner and the courts alike. We see as 97.61% of the earth's water resources happens to be in ocean and only unavailable for the human consumption. So what remains ready for the human consumption is only 0.124 water, which is present in river, lakes, streams, and tube wells, and the 70% water in that scenario, with a very peanut of the water resources and the volumes of the water is available for the earth's consumption, the human consumption. And out of that, if a situation have come to us which says that 70% of the available water in India is contaminated and unsafe, and then 7% of the town and cities in India have actually treat their discharge their water without any kind of a sewage treatment and the treatment, then in such a scenario, what remains that one is that contaminated water which appears here, and the contaminated water is one thing that is being a cause of concern. The another concern is that do we have water resources or not? If the water resources are depleting so fast, then the depletion of the water resources, be that the rivers turning into sewer, be that the aquifer, be that the water table, be that the groundwater, be that the rivers in lakes which are drying up because of climate change scenario, in that way that the crisis appears to assume a very ugly picture, and in that case it have a great impact on the economy and as well as the health of the people of this country. And that's why the report suggests that the 73 million work days lost annually, although this data is very old, but it just gives a glimpse that how the waterborne diseases and the health crisis because of the polluted water have been one of the factors which are going to adversely affect the economic scenario and as well as the health scenario. And as the studies suggest that many million days work days lost annually due to water related diseases, and still because of all public health policies that the control on the water related diseases have not taken to a satisfactory note. And then we see that it requires a mammoth funding and to to invest into water related diseases and its cure and the health aspect. And we see that even the high altitude lakes have not spared from the pollution, and even the remote water sources face acute contamination. And the promises of the International Drinking Water Supply and Sanitation Decade program, which was heralded in 1981 to 1919, how that goal is to be achieved in the Indian context. At one hand, we have the waterborne diseases. On the other hand, the health cost happens to be very staggering and very exorbitant. On the other hand, the pollution is assuming a kind of a menacing proposition, and how the contamination of water from all the sources, diversity of sources, are going to affect the entire water resources in this country. Then it requires honing of the strategy that is called the legal policy for the water resource development, and we have to analyze in a very proper parlance and perspective that how legal policy for the water resources in this country have a kind of an equity model, and what are the primary goals of the legal policy for the water, and what are its promises, what are the pitfalls, then what we see that the Indian water policy is having a poor urban bias. And pro-urban bias here means that most of the water resources development happens to be the infrastructural development, which primarily targets and benefits the one hand the industries are the major recipient of the water resources, and then we see that the hydroelectric generation requires a lot of water. The population at the urban areas also having a greater water demand. So at one hand, we have the industrial demand for water. On the other hand, we have the urban demands for the water for daily consumption. On the third hand, we have demand for exacting demand for water to create a multi-purpose project and hydroelectric project and irrigation purposes. Then we see that the most of the water policy in India has been designed in such a manner which have crept into a kind of a pro-urban bias, leaving rural population undeserved and without access to the drinking water. That situation is quite unequitable, and the sense of equality and equity demands that before there can be any kind of ecological catastrophe and the dam burst, which happens to be a major source of water resources in this country, as India is boasting about the riverine country and all 14 major rivers and minor rivers and its tributaries are gushing towards, and some of the rivers in India happens to be the perennial, although the perennial character of the water have been reduced and the very identity of the water from river to converted into a sewer. And in that scenario, whatever project the government of India has launched to secure a water security, that has to be re-examined and revisited. The ecological catastrophe here means that in case that the dam happens to burst, then the developmental model which excessively relies on the dam building and the river valley project and the multi-level project of hydro project, then we have serious situations and serious conditions and serious repercussions on the floods, droughts, land erosion, soil degradation, and deforestation, beside the water scarcity in the rural area. So the challenges are very formidable, and it requires a very judicious allocation of the government resources and the empowerment of the water resources to have a very fair priority and a distribution pattern that must be not only equitable, but it must have some kind of an egalitarian values. As we recall, Dr. B.R. Ambedkar's the entire movement of the caste and annihilation of the caste begins the denial of the water from a well, and thus the water happens to be a kind of a turning point in the life of Dr. B.R. Ambedkar. In that sense, the discrimination on water allocation and the urban bias of the water urban bias into the water planning and policies, including the legal policy, is a situation which cannot be said to be based on equity and egalitarianism. That's why India's water policy is neither sustainable nor viable, and the dependence on the mega irrigation project, canal system, river damming, and large-scale infrastructure development have fundamentally altered the water use priorities and access pattern, and it requires that we have to create a legal policy for water resources by developing a different model, taking clues from the failures of the past models on the water resources. In this case, we can see now that after having its priority and the legal focus and the foundational goal of the water policy in this country, legal policy for the water resources, we are going to now explore the evolution of water legislation in India and try to see that how the evaluation of water legislation in India have given adequate attention to all dimensions and variety of the dimensions of the water, not only the pollution of the water, not only the control of pollution, but creation of an access and equitable resources of the water. In that case, we have divided this evolutionary process of the water legislation in India into 1974 era, meaning thereby the Water Prevention and Control Act of 1974, which we have as of now, is a very comprehensive legislation. Although this comprehensive legislation has a 12 years old history of lawmaking, and the reason attributed to that the water comes under the 7th schedule in the state list, and therefore it being in the state list, the state are supposed to make law, but because of the consent and consensus of the state and ratification by the states, then they have abdicated their powers to the parliament to come out with a law known as the Water Prevention and Control of Pollution Act in 1974. The beginning of this law has been made in 1952, but we are trying to see that prior to the enactment of the Water Act 1974, what laws we had. Then we see that Shore Nuisance Act 1853, that law has been taken to its ultimate discussion when we were delivering the lecture on the common law remedies for the environmental protection. Then we have a series of provision engrafted under the Indian Penal Code in relation to the chapters of health, safety, and we have seen right from the falling of the water and the reservoir and the water courses, there is an elaborate mechanism in the Indian Penal Code 1860, and then the Colonial Law of Easement Act of 1882, Indian Fisheries Act 1897 are some of the basic law which has paid adequate attention to the question of the water resources in this country. Although these laws are piecemeal, sporadic, fragmented, and having a very sectoral focus, as the Shore Nuisance Act was confined to the shore nuisance in Bombay and Colaba, whereas the Indian Penal Code have taken a very wide perspective of looking at the purity of the water and the wholesomeness of the water by its elaborate provision. Indian Fisheries Act have been fishery driven law, and the Indian Easement Law happens to be a water distribution system law where some riparian rights and easementary rights have been conferred by the Indian Easement Act. Then prior to 1974 Water Act, these laws have been in practice and vogue, but when the Water Act was put into the statute book, it has created as one of the most comprehensive environmental legislation. Before we discuss the Water Act, the one law is the Odisha River Board Act is also very important, that has given rise to a kind of a river law. And there are two laws. One is the River Board Act 1956 and Interstate Water Dispute Act is the another law that also needs to be mentioned in the category of the laws which we have witnessed prior to 1974 and the enactment of the Water Act 1974 to Interstate Water Dispute Act 1956. These two laws have tried to resolve the water dispute. As why? Because it is one of the most litigated area and dispute prone area, simply because, as has been mentioned in the beginning, that water is considered as a metaphor of the power, and when it is considered as a power, then the one who possesses the water is more powerful. That gives rise to certain dispute. It is under these circumstances that the Interstate Water Dispute Act 1956 was passed and the River Board Act was passed in 1956, which have attention to the river. So we have categories of certain laws in the water resources until and unless we had a very comprehensive law in 1974 by creating a central pollution control board, a state pollution control board, joint board, which have focused on the prevention, control, and maintaining the wholesomeness of the water. That kind of resolution was found in 1974 water law, and in concurrent to the development of the Water Act in 1974, there was thought to be a law known as Water Cess Act that wanted to have levying of certain fee and collection fee on the water consuming by the industries, and the industry are also enjoined upon to fund for pollution control measure, and as well as by levying some cess and collection of fees on the water consumption, the government tried to have the judicious husbandry of the water resources. Then, after prior to 1974, in 1974, in 1977, the Water Cess Act, we come across the National Water Policy, which formulated 14 years after the Water Act, mandated a sustained yield, use, and equitable distribution. Here, the attention is drawn to the fact that the water policy which were earlier in practice in Wagyu have been very short-sighted, and the failure of the water policy model which the India has adopted, which were bereft of equity, egalitarianism, and having an urban bias and discriminatory allocation, and have created some ecological and water catastrophe in matters of flood, drought, land erosion, soil degradation, and deforestation in rural hinterland, was slightly tried to be corrected in National Water Policy 1987. The one thing is that it uses the word sustainable use and yield of the water resources, number one. Number two, it talks about the equitable distribution. It talks about the irrigation, the water in a very holistic concept of not only the urban requirement, not only the industrial requirement, but it prioritize the drinking water and try to see that how the competing sets of the demands which are being created for the irrigation, hydropower, navigation, industrial use are to be brought to its ultimate focus in the National Water Policy of 1987. Then after 1987, we find another landmark in the water resource management, that happens to be what is called the Coastal Regulation Zone 1991 regulation, which have regulated construction activities and in the coastal zone and provided a kind of a protection and conservation of the backwater and estuaries from the pollution. This law has primarily based on United Nations Convention on Law of Sea of 1981, as well as it has given focus to the marine water resources or the marine environment. That was the focus. And then we have the wetland law in 2008 because of the judicial pronouncement on the wetland laws, especially the People's United for Better Living in Kolkata versus State of Bengal. The High Court of the Kolkata has laid down that even though the India doesn't have any law relating to the wetland conservation, but if there is a law at the international level known as uh, Wetland and the Waterfall Habitat Convention 1971, popularly known as the Ramsar Convention, then it is incumbent on us to give effect to the international law norms and try to protect the wetland which is drying and for the time being appears to be drying, but that dry land conversion of the wetland into dry land does not strip its identity as a wetland, and as a wetland it has a right to be protected and to be preserved. Then the canopy and the range of the water law which is evolved in India, which starts from the Shore Nuisance Bombay and Colaba Act 1853, which start from the Indian Penal Code, which start from the Indian Easement Act, which start from the Indian Fisheries Act, have and which start from the River Board Act 1956, which start from the Interstate Water Dispute Act, and besides the plethora of laws which has been passed in the colonial India in matters of the water legislations and water protection and prevention and control of pollution, we have a deep sense of commitment and a concurrent and parallel and satellite law relating to the customary rights of the water resources in this country, and the customary laws in relation to water is equally important in giving fillip to the water resources and conservation in this country. Then the central to our discussion lies the Water Prevention and Control Act 1974 along with its economic version of the Water Cess Act of 1977, and we see that how a radical shift has occurred in 1987 by envisioning a very progressive sounding water policy giving effect to, and then its ultimate culmination to coastal resource zone law and the wetland law, and in the present circumstances the River Zone Act of 1922 is the another piece of law which gives the entire evolution and development of water legislation in India. Having understood the entire range and the canvas of the water legislation in India, we will try to see that what Water Act 1974 contains the core provisions and the core framework, and what is its institutional structure, what are the standards and monitoring, what is the consent mechanism which has been inbuilt, what are the enforcement power, and what are the penalties and punishment and imprisonment which has been prescribed in order to bring and maintain and restore the wholesomeness of the water. In that sense, we see that the Water Act 1974 as a basic law on the water resource development in this country have tried to envisage an institutional structure which was hitherto not known to Indian environmental law, and that structure was the Central Pollution Control Board, the State Pollution Control Board, and the Joint Pollution Control Board, or the interstate coordination. We have a Narmada Water Dispute Tribunal, we have the Interstate Dispute Tribunal. That institutional structure which were already in existence, which has been prescribed by the different law prior to 1974 Water Act, that remains in practice and vogue, but 1974 law have honed out a new strategy to control, to, to control, prevent and abate water pollution at one hand. On the other hand, it try to maintain and restore the wholesomeness of the water quality. On the other hand, that is being done by the instrumentality of the Central Pollution Control Board, the State Pollution Control Board, and Joint Board. The Water Act also tried to set some water standard, meaning thereby all environmental law mercilessly dependent on the standard setting. We must have certain benchmark, we must have certain standard to examine that what water is worth of drinking, what water is worth of bathing, what water is worth of irrigating, and what water is worth for navigating. So we have a varying standards, and this law tried to see that we must have a very elaborate and exotic standard setting exercise in relation to maintain, restore, and to have the wholesomeness of the water. And it has also tried to set the standards of water, affluent discharge, affluent standards, and it establishes the laboratories, sample analysis, testing, and it confers a wide range of power to the authorities, to the board, and to the person concerned, to the specialists and laboratories to see and check the water level from the industry. Here, that is being permeated and promoted by a system of consent mechanism which has been given under chapter 5th of the Water Prevention and Control Act, and chapter 5th is very important. It has a very elaborate provision right from the consent mechanism that every industry are supposed to seek consent from the Pollution Control Board, and after seeking the consent from the board, then it can only be entitled to discharge its effluent into the water bodies, and that too after the treatment. And periodically that enforcement power also rests with the board, and the inspectorate and the commissionerate under the Water Act 1974 collect the sample, issue direction, and issuance of the direction also result into the closure of industry if any industry is supposed to not discharging its legal obligation and statutory requirement which has been given in the consent mechanism and the license. Then the board is under its duty to pass direction, and pass direction means here to stop the supply line and as well as declare the closure of the industry, notwithstanding that the closure will bring unemployment and loss of revenue. At the same time, the mechanism of the Water Act on the fifth pillar is that it prescribes punishment, the penalties An imprisonment clause has been mentioned under Section 49 of the Water Act, and that prescribes the same kind of the punishment as we have witnessed, that it is partly based on no fault, partly based on vicarious liability, partly based on criminal liability, partly based on the strict liability, partly based on polluter pays principles and precautionary principles, and the mechanism of the entire penalties and the imprisonment thus try to see right from the institutional mechanism to standard settings and monitoring of the consent mechanism and licensing system regarding the discharge, and the power of the enforcement and inspectorate, and the penalties. The Water Act's the core framework try to see and a comprehensive attempt to address the water pollution in this country, and the very objective of this law extend beyond prevention and control of the water pollution towards the maintenance of the water quality and restoration of the wholesomeness of water. With this, I hope, dear learner and viewer, the present lecture will set some basic understanding about the purview and the prospect of the water law and policy in India. With this, I thank and I wish you a happy learning.